We shall get it started shortly, royal family. Appreciate the donations. Let me know where y'all tuned in from, man. We about to get started. Appreciate the donation. Appreciate the Cash App donations. Peace and love, everybody. Peace and love. You're now rocking to the sounds and vibrations of your boy Malik Kilam, also known as Don Kilam. And as always, prosperity is your birthright. Let me do a sound check, man. Sound check for the one time, man, because we're going to go over some great information today. Appreciate the donations, because you already know the information is going to be great. Sound check for the one time, man. All right, sound check is good. Sound check is good. Now check me out. I want to show y'all something, man. Check me out. Kush Snacks on deck. We got the Don Kilam Kush Snacks. Don Kilam Kush Snacks. You pretty much have to run up on me and come to an event to get these right now, but we will be offering them online. We got Rolex Walton in the building. Peace King, North Carolina in the building. Appreciate the donation. We got the Kush Snacks. Check them out. Y'all can even go on my YouTube page. I posted something on the YouTube community page. I did a video. I want y'all to see that, man. Y'all gotta understand, I'm out here making moves. Making major moves. For the people, man. They gonna hate. Let the haters hate. That's their job. Keep it pushing. Ain't got nothing to do with you. Trying to share my screen. Hold on 1 second. As always, I'm not a licensed attorney or tax expert. This information is going to be for educational and informational purposes only. Yes, indeed. Make sure y'all can see my screen. Hang on 1 second. I got to make sure it catches up. Alright, y'all can see the screen. Now look, check out the Kush Snacks. Kush Snacks on deck. We got CBD and we got the THC. Right now we just got the THC on deck, but we'll have the CBDs on deck soon, man. Just for the everybody that wants it for the medicinal purposes, for the medicine purposes. Yes, they did their thing. They did their thing, man. They did their thing. Yes. If you're following on the Instagram, my Instagram is Don_Kilam, DON_KILAM. The Facebook is Jeffrey McBride Bay. So if you're following on the Facebook, man, I am in the Facebook groups right now. So check that out, man. I appreciate everybody that's following along, everybody that's in the building. I appreciate it. We got Al Bynum in the building, Grand Rising. So yeah, we got the Kush Snacks on the way. Be sure to check that out. Now look, I need everybody to understand first and foremost truly what's going on. I'm starting at the beginning because I know that there's beginners that's following me, okay? I know there's beginners that's actually following me. So, we always got to start from the basics. Go to the definitions. 28 USC 3002. All right, you got to understand what's really going on. Understand that United States means federal corporation. Anytime you say you're a person, that means you're a corporation. All right? And anytime they say you owe a debt, that's owed to the United States. Anytime you go to court, it's really not a court created by Congress. It's not a republic court. It's a tax court, which makes it for corporations. So court is just set up for corporations. I need everybody to understand that. When you do your own study and research, you need to understand this is what your name was turned into. This is the basically Rolex Wallet, and I appreciate the donation. This is how I can explain it in simplest terms. The sole proprietorship. Make sure y'all get closer to me. Make sure y'all can hear me good. The sole proprietorship. That's your name. Your name's a business. If you're going to work, I don't care if you clock in 9 to 5. You're working for your name. So either you can be a slave or you can be something great. Really, we're all one and the same, to be honest with you. But they got this status. We got higher status and lower class status. That's just what it is. But yes, man, we got the Stoner Patch Kids. Strawberry Stoner Patch Kids with Don Cologne. That's tight. So, a sole proprietorship, also known as the sole trader, individual entrepreneurship, or proprietorship, is a type of enterprise owned and run by one person in which there is no legal distinction between the owner and the business entity. That's a sole proprietorship. That's your name. And I'm about to start going through some documents. If you want these documents, I am requesting a $20 donation. I'll make sure you get it. And that's just for my time. All right? That's just for my time. And this stuff is important. You need to understand why this is important. Sole proprietorship. You understand what that is. And this is the first, listen, this is not where you stop, okay? This is not where you stop, but this is where you can start. Benefits of an LLC, all right? So instead of having a proprietorship, you're going to want to have an LLC. Turn your name into an LLC. It limits your personal liability, avoids double taxation and pass-through deductions, less administrative hassles and paperwork. And really, it's with the operating agreement that's going to save you. But if you have everything set up correctly, then it's going to be easy to enforce your claims. So benefits of a, let's say, Nevada LLC. We'll do Wyoming. They're the same benefits. Wyoming and Nevada, they're the same benefits. But I just want to pull up the easiest thing so you can just go to it. Usually they just pop up in Google, like, you know how I usually just. So we'll just go back to Nevada then. But first, the reason why I'm picking these states are charging order protection states, okay? Charging order protection states. You got Alaska, South Dakota, Nevada, Delaware, and Wyoming. So we'll just go there. We'll click this and see what this says. Protect your assets. Assets. What is an asset? That could be your car. That could be your house. Your kids could even be an asset. You understand? When you read through this, it's just showing you. Today there's only 5 states providing charging order protection to single-member LLCs. In fact, Delaware, Nevada, and Wyoming are often considered 3 of the friendliest states for business in the United States. The remaining 45 states limit charging order protections. All right, and it even talks about trusts. Trusts are similar to corporations or LLCs because they are considered separate legal entities. However, the trust must be irrevocable to obtain this status. Otherwise, revocable trusts are often just regarded as an extension of the trust owner. In an irrevocable trust, the assets are transferred to the trust. Now, when you have a holding company set up and an operating company set up, you'll get the same type of protections, but you need to understand to still have a trust on the private side when dealing with this business. And I hope this is making sense. This dude funny. Now, so we got this. And then we go into the files. This is exactly what you're going to be getting. This is the email right here. When you send your donation, this is the email, the files that you're going to be getting. All right. Now, I want to talk about the commercial lien process first, so you understand really what's going on. All right, first, the true bill in commerce. What is the true bill in commerce? This is a ledgering or bookkeeping accounting with every entry established. This is your first affidavit, certified and sworn on the responsible party's commercial liability as true, correct, and complete, not meant to mislead. It must contain a one-to-one correspondence between an item or service purchased or offenses committed and the corresponding debt owed. The commercial relationship is what is known as just compensation, Fifth Amendment to the Constitution. In relationship between the government and the American people, a true bill is called a warrant. In relation All right? In relationship between the government and the American people, a true bill is called a warrant, Fourth Amendment to the Constitution, and the direct taking of property by a legislative act. IRS and the like is called a bill of pains and penalties. Constitution, Article 1, Section 10, Clause 1, and Article 1, Section 9, Clause 3, Bill of Attainder. We're going to go through some of this stuff, not all of it. But I need y'all to understand really what a commercial lien is, because a lot of people are not filling them out correctly to start to end. Here it is. Commercial lien, the most potent weapon. And this right here is 82 pages. And it says, a disclaimer, this manual is intended purely as a communication of information in accordance with the right of free speech. It does not constitute either general or specific legal advice. Anyone seeking legal advice should consult a competent professional. Know that. This is not legal advice. So the scope and purpose of the manual. This manual is an introduction and primer to the commercial lien strategy. It does not pretend to be the final word on the subject. The authors and editors have synthesized material from several sources. We have organized it into a form that should be comprehensible to the average reader. After reading this manual, you will know the fundamental principles of the strategy. This understanding plus the bibliography in Appendix A will allow you to do further research on your own. Some notes on the sample briefs. Now look, the commercial lien strategy, the background. Faced with corrupt lawyers and judges, no litigant can expect to win in court by simply playing defense. To beat them, you must be able to scare them. You must be able to make them respect you, and that means you must be able to take the offense, attack them personally. Unfortunately, judges, lawyers, and other government officials enjoy various levels of personal immunity provided by both law and professional courtesy. How do you sue a lawyer for malpractice? You hire another lawyer. If you can find one who will take the case, how do you sue an IRS agent for violating your constitutional rights? Only with great difficulty. How you sue a judge for railroading you in court? You don't. As a practical matter, private citizens can't sue the President of the United States, a governor, a judge, or even an IRS agent for failing to obey or enforce the law. If we try to sue in court to compel our government officials to obey the law and perform their lawful duties, the judges routinely ignore our petitions and laugh us out of court. Because legal and de facto immunity shield government personnel from being sued for committing offenses against the people, the public is legally disarmed, unable to aggressively sue the government or its agents and compel them to obey the law. As a result, the public's legal posture is fundamentally defensive. We try to duck, dodge, and hide in legal loopholes to defend ourselves against the government and the courts. We try to escape, evade, and avoid. We seldom counterattack against our antagonists, largely because we think there are no lawful weapons to do so. However, it appears that a powerful, offensive legal weapon may now have been discovered, tested, and proven for common citizens: the commercial lien. We don't try to sue a government official for failing to perform his lawful duties. Instead, we simply file a lien that encumbers the official's personal property and credit rating like a ton of bricks until he voluntarily satisfies our demand to perform his lawful duty, and we in turn voluntarily agree to exercise the lien. And there's some examples of the strategy. Example 1. Edward J. Wagner, an hourly employee at General Electric, received notices of levy from the IRS garnishing his wages and monies received from several other sources. Wagner tried to pursue GE not to honor the notice, since they were not properly attested as true bills of commerce. His efforts met with no success. After giving GE proper notice and demand, Wagner and his wife filed a commercial lien in an amount of, it looks like $224 million. In the lien, Wagner impounded GE inventory that he had worked on, including air conditioner units, analyzing equipment, etc., as security for the lien. This is similar to an auto mechanic impounding a car he had repaired, a mechanic's lien. This meant that GE could not lawfully sell or transfer the equipment until the lien was either extinguished or satisfied. Among the reasons for the high dollar amount are that the law allows for such high sums as reward for damages incurred, and it generally has to be large enough in relation to the size of the company involved to get its attention. Otherwise, such a large company might just ignore it. Consequently, a legal war followed, and by June of '92, GE had gone to court several times trying to remove Wagner's lien, all without any real success. This was in spite of the fact that the GE had the best, most highly paid, and highly motivated lawyers. In June of '92, the first major victory for Wagner's came. The IRS issued 4 different official releases of levy, one to General Electric plus 3 other places where they had wages and income that the IRS had levied. The Port of Seattle, Dean Witter, Reynolds, and the Ohio State Life Insurance Company. These effectively released the IRS attachments on the Wagner's income and assets. That's a pretty solid testimonial to the power of arguments in Mr. Wagner's lien. Now, if you want to finish watching this, if you're on the Facebook, look me up on the YouTube. I am live on the YouTube. I post a link in my actual page as well. Much peace and love. Catch y'all later. Alright, I'm about to get to the good stuff, y'all. I gotta get some edibles in. I gotta give me some Kush snacks. That's my breakfast today, is the Kush snacks. Hey, I appreciate the donation. Keep getting donations, y'all. I appreciate it. There's more examples. But I just want y'all to see how powerful and important these liens are. Now, although the lien strategy, it is explosive, because this is how you gotta understand, everything is commerce. Everything is in commerce. They have to operate just like you. They have bank accounts just like you. They have credit scores just like you. There's no special credit score for a government official. I mean, there probably is, not the ones you're dealing with. You know what I'm saying? They're in the same system as you. The system that you chose to be in. They just get a different type of rank or status. Now, according to their rules, according to their laws, they're protected. And you're not. So you must know this. The commercial lien, which is authorized both by the common law and by Title 15 of the United States Codes, is reportedly the same lien that IRS uses to attack Americans' homes and cars. However, some litigants do not depend upon Title 15, but upon the common law of negotiable instruments, aka commercial law. And I would say that a lot of corporations do the same thing. Private contracts. Private contracts. Hannibal, got your donation. I appreciate you, King. As such, it is almost impossible to remove a commercial lien without the approval of the individual claimant who filed the lien. Although a commercial lien can be challenged by a common law court or by a Seventh Amendment jury trial, it does not require a court process or a court judgment for its establishment, or to make it valid or to execute it. Therefore, it appears that the courts may not be able to simply extinguish this lien on their own discretion or on a motion from the lien debtors without the voluntary approval of the person who filed the lien. Traditionally, these liens can only be removed by the voluntary decision of the person who filed the lien, by the decision of a constitutional common law jury trial, or by the waiting 99 or 100 years since the common law has been smothered in the USA. All judges are essentially powerless to overcome the liens. Chauncey, got your donation. I appreciate you, King. The right way law. Before utilizing any of the procedures suggested in this manual, we strongly suggest that you join an organization called the Right Way Law. I don't suggest this, but this is in the stuff, you know. Read through it. It's Title 42 Civil Rights Violation Suits, okay? That's what they're talking about. To effectively use the commercial lien strategy, you should have a good grasp of the principles of law involved. Immediately following the introduction is an essay written from a Christian perspective, explaining the foundations of the common law. And the reason why I think that's important is because the Bible is a fact in the courtroom declared by Congress. So they use the Bible for everything. The Bible is your actual estate planning that they're using. This explanation will no doubt be very difficult from anything you have been taught. In fact, licensed attorneys may have the hardest time understanding this because they have been taught to think only in a certain way. An intelligent lay reader will probably understand the following article without much trouble. Most people have been hypnotized in believing that the meaningless scribblers of legislators, presidents, etc. constitute the law. After reading this stuff, you'll understand. So look, the commercial affidavit process. The commercial affidavit process, or CAP, is perhaps one of the most powerful devices available to the common man for righting wrongs and accomplishing justice. Read through this right here. And I seen this right here. I'm going to show you where I seen the same document. Right here from Freedom School. Same document that I'm reading from. This one's 74 pages. The one I got to 82. I don't know what the difference is. Gunner got the donation. I appreciate you, King. And it's the same stuff right here. Now, I say read through it because it helped me have a greater understanding. But I'm going to go through the actual liens now. So we're going to go through the files that you're going to be getting, okay? But that's in the file. It's 82 pages. But it's gonna break down the actual what's going on, why it works. Alright? Read it and learn it so you become empowered. So can't nobody knock you off your square. And when you ever get stuck and they try to debo you, if they ever try to scare you, remember this. Find case law. You're enforcing your rights. As long as it hurts nobody, you can do what you want. You're enforcing your rights. So you must know what case law. This is all case law. The master asks the questions. The slave answers the questions. They're public servants. That means the public is the master. I need you to understand that. No state shall convert a liberty into a privilege. There can be no sanction or penalty imposed because one of this exercises his constitutional rights. So this is all case law. Your photograph and fingerprints are your property. Do not give these away. Do not sign anything. Your signed manual is your property. Do not give it away. Especially do not sign fingerprint cards or booking sheets. Hotel registry, they are required to get your signature on the fingerprint card before they can fingerprint you. Going to jail or prison is voluntary. You or you represent must sign the contracts. How many years of slavery are you willing to... This is Davis versus Mississippi. So I need y'all to know what's going on. I'm putting that in the chat. I'm going to put the link to that in the chat. I didn't see it pop up. But that's it. Look. I found that Freedom School case law. All I did was search is you cannot turn a right into a crime. You're always going to have to keep evidence, proof of mailing and contents that's mailed. Get that notarized. Always keep a certificate of non-response when they don't respond. Get that notarized, send it off. You got to keep track of everything. Now, this is the actual lien right here. This is going to be considered a security under 15 USC. It's just a plain affidavit. All men and women know the foundation of law. Now, before you do these things, you have to put, say you got an officer or a judge, right? You got to contact their superior first. I'm going to say that again. You have to contact their superior first. You have to seek remedy between you and that person. If you can't seek remedy between whether it's an officer or it's a judge, you do it through letters first, affidavits. They don't respond, you send them a certificate of non-response, and you go to their supervisor. Their supervisor doesn't respond or doesn't give you the remedy that you seek. Then you go to their insurance company. Figure out who licensed and bonded them. If they don't give you that information, it is illegal. You take it to the mayor. You take it to the governor. And then the IRS, the district courts. The real courts is the IRS, but you take it to the district courts and then the IRS. Before you start implementing these liens. You have to put all parties on notice first. How can they try to resolve it and give you remedy if you didn't try to resolve it first? Harney, appreciate your donation. Is it making sense so far? Let me know if it's making sense so far. Now, here's the maxims. This is you laying down the law. All men and women know the foundation of law. And commerce exists in the telling of the truth, the whole truth, and nothing but the truth. Truth as a valid statement of reality is sovereign in commerce. An unrebuted affidavit stands as truth in commerce. An unrebuted affidavit is acted upon as the judgment in commerce. So when your affidavits are not responded to, they become the truth and they become the judgment in this case. Whatever case you're laying down for that matter. Y'all not seeking remedy because y'all letting them say whatever. Send that shit back. I don't want it. And then y'all keep going up to the higher ups and superiors. When this becomes a security, you're putting that as a security. Then we're going to the SEC and the FTC, the Security and Exchange Commission, and the Federal Trade Commission. Because if they don't investigate and don't find something wrong, their ass is grass. They're doing their job. Now, understand this. Guaranteed, all men should have a remedy by the due course of law. If a remedy does not exist, or if the existing remedy has been subverted, then one may create a remedy for themselves and endow it with credibility by expressing it in their affidavit. Ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available to anyone making a reasonable effort to study the law. All corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distresses. Hence, governments cannot exercise the power to expunge commercial processes. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard, because no bonds means no responsibility, means no power of an official signature, means no real corporate political power, means no privilege to operate statutes as a corporate vehicle. And I need y'all to understand that, because when you come into the sole prop, you sign the birth certificate, now you're signing up to be a government employee. And now you're creating bonds in the private. That's why I said, do you understand your charge? So check this out. I'm going to say it again. The legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard. Because no bond means no responsibility, means no power of official signature, means no real corporate political power, means no privilege to operate statutes as the corporate vehicle. The corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. Municipal corporations, which include cities, counties, states, and national governments, have no commercial reality without bonding of the entity, its vehicles, statutes, and its effects, the execution of its rulings. In commerce, it is a felony for the officer of a political public office to not receive and report a claim to his bonding company, and it is a felony for the agent of a bonding company to not pay the claim. If a bonding company does not get a maleficent public official prosecuted for criminal malpractice within 60 days, then it must pay the full face value of a default and lien process in 90 days. Except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge without a counter affidavit, any affidavit, or any commercial process based upon an affidavit. Judicial, non-jury commercial judgments and other originate from a limited liability entity called a municipal corporation. Hence, must be enforced by a commercial affidavit and commercial liability bond. A foreclosure by a summary judgment, non-jury, without a commercial bond is a violation of commercial law. Governments cannot make unbonded rulings or statutes which control commerce, free enterprise, citizens, or sole proprietorship without suspending commerce by general declaration of martial law. It is tax fraud to use courts to settle a dispute controversy which could be settled peacefully outside of or without the court. An official, officer of the court, policeman, etc. must demonstrate that he or she is individually bonded in order to use a summary process. An official who impairs, debauches, voids, or abridges an obligation of contract or the effect of a commercial lien without proper cause becomes a lien debtor, and his or her property becomes forfeited as the pledge to secure the lien. Pound breach, breach of impoundment, and rescue is a felony. It is against the law of the judge to summarily remove, dismiss, dissolve, or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. Notice the agent is notice the principal. Notice the principal is notice the agent. Public hazard bonding of corporate agents. All officials are required by federal, state, and municipal law to provide the name, address, and telephone number of the public hazard and malpractice bonding company and the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud, 15 U.S.C., and is prima facie evidence grounds to impose a lien upon the official personally to secure this public oath and service of office. And then it's going to go into the lien, how to actually set up the lien. I hope that's making sense for everybody so far. Appreciate the donation. I'm getting more donations. Appreciate you. So, most liens are like 10 pages. The parties, it's gonna be your name versus them, all right? You're gonna be the claimant and they're gonna be the debtor when you're doing the liens. Then you're gonna do your allegations. And then you gotta do it point by point, each allegation. And then you do the allegations and you do the ledgering. When the ledgering's done, this is what's gonna, all it is breaking down how much you're saying they claim to owe you and where you're getting that value from. Every offense has a value attached to it. That's how they rock. So you use their values. You look up their laws. All right. And most of it is going to be under the American Constitution and the United States codes. Color of law. Color of law violations. Now, Also, there needs to be just a plain statement of truth or a plain statement of facts. And this is going to be your actual statement against them. You get that notarized. You create your own statement just like they do. And then there's another you just label all the offenses. You attach that goes with it. Then you have to prove what you mailed. You put what you mailed and get that notarized. Every time you send out a package, you need to make sure you proof of mailing and contents mailed. When they don't respond, you always send a certificate of non-response. Sometimes you can just have your notary send it off. Now, you make sure they get the notice of default and opportunity to cure. Once they go into default, you still give them an opportunity to right their wrongs. They haven't responded. They haven't given you remedy. This is, hey, we're giving you one last chance. You can cure this. And it's more law, man. You got to make sure you include your definitions. I want y'all to go through this too. It's just breaking down more about the commercial lien process and where we're getting the law, the public law policies. And then when they go into default, you send them a notice of default. The reason being, why, who it's going to, what they defaulted on, including your register numbers. Now you're going to have to create your own, you're going to have to enforce your own claims. That's what these are. So this is a writ. And it's going over this is the definitions and why we're going to enforce it. A writ is an order. So we're creating an order. And with this is the order that you're going to need to acquire their property or credit, whatever it may be. Breaks down the levy, actions prior to the levy. The plaintiff may request that the sheriff's office contact the defendant and make a demand to settle the debt on the plaintiff's behalf. Breaking down what a true bill in commerce is. And then there's the instructions again. Now, then this is when you actually enforce the International Commercial Claim Administrative Remedy. And we're just asking, all we're asking is for peace and harmony. We want peace. And this is after you enforce your claim and your writs, this is what you're going to put on record with the sheriff's office. Put it on record with the county, put it on record with the state, and then you take it to the sheriff. This is how they go get your stuff. This is how mechanic liens get your car. And this goes with it too. The public hazard bonding company, you have all that information. The ledgering, the surety. This is how they do it. This is the bookkeeping behind the scenes. When you go to jail or when they take any of your property, this is what's going on behind the scenes. But you created the bonds. You got to understand that. I've already went over the GSA bonds. You created the bonds. More ledgering, proof of the allegations. This is us creating our case. Then another affidavit of non-response. And then proof that we mailed. Make sure you read through all of that. I know I didn't cover everything because this is a lot of paperwork. But I wanted y'all to know, listen, you have an issue, problems arise, you send these letters off first. You send them off. We're going to let the mayor know. Because they have to, listen, try to get a report done and they're going to say, we investigated it and we didn't find no fault. You file your own report still. You file your own affidavit. That's why I was trying to show you. Listen, this is your affidavit right here. You write a statement on them people, the cops, the judge, whoever it is. If you don't have this, it's not going to be able to jump off. You decided to make your own statement. You don't need nobody to make that statement valid. That's your statement. You just need it notarized. And then we're going to start making the mayor known and whoever damaged you. And then we just work our way up. Work our way up the ladder. All right. Then once we got the state involved, the Secretary of State, we got the states involved, we got everything on file with the county. We can take all this to the sheriff's office, and it's good as gold. It's good as gold. They're gonna pay you because you're doing everything right. They don't want their shit tied up. With that, I'm out, man. I know I'm early. I don't see too much interaction today, but hey, that's the affidavit of obligation and commercial lien. You want this document, send a $20 donation to the Cash App. I'll make sure you get it. Make sure your email box is in a memo box. If you need help with this, we will help you. Just just respond to the email. We require a $500 donation. 10% of anything recovered will help you. Just make sure the crimes are nonviolent, all right? If you had any property taken, whether it's a car, whatever, it could be your kids, man. You can put a lien, man. You can put a lien on them, but you need to do it right away. With that, I'm out, man. Much peace and love. Remember, prosperity is your birthright. Peace.
Live from Columbus. you.